Good morning, everyone, and welcome to the first episode of our new webinar series, Commercial Collections Corner, touching on all things commercial collections. Today's topic is arbitration. My name is Jim Kozelek, the chair of the Weltman's Commercial Collections Group, and I will be the moderator for today's session. So you're probably sitting there thinking, moderator, but it's just you, Jim. Oh no, it's not just me. I have a very special friend with us. Yoda has joined us. Yoda is my cosmic advisor, and he also acts as a hall monitor. So I want to make sure that you all behave yourselves because, believe you me, he will use the force. So I'm a shareholder here at Wellman, as well as the commercial chair business, or the commercial unit business chair. And some of my responsibilities as the commercial business unit chair is to oversee the overall operation of a group that has about 30 people spread throughout our 7 different offices. As the managing attorney for the Columbus office, I am overall responsible for the day-to-day operations of the firm's second biggest office. We just moved again within down the street in Dublin, and so we are kind of getting used to it. We just literally started on Tuesday, so we're still trying to figure out where everything is. But my camera's there, my computer's here, so we are good to go. So that's a little bit of background on me, but before we get started on the questions and the topics, and other than the rule of behaving yourself because Yoda is watching us all, I would like to tell you about a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. My thought is that if it's timely on the topic the question that I'm addressing, then I will try to get to it then. But there also may be some opportunities at the end to review questions or ask questions then. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all the attendees. There's no presentation slides. However, there is a flow chart that I was presented with a number of years ago that I think is really helpful in understanding the arbitration process once an arbitration is commenced. We'll send that to you because I think it touches on a lot of the nuts and bolts of an actual arbitration proceeding. There will also be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. So why don't we get started with the first sort of topic that I wanted to discuss with you all. Do I really have to arbitrate? So the answer is no. So we don't have to get to 2 and 3, and I can give you guys back 57 minutes. I bet that's what you were hoping to hear. Unfortunately, that's not the correct answer. In my most lawyerly voice, I will tell you the answer to that question about do I really have to arbitrate is it depends, right? Because arbitration provisions, just like other contracts, are written differently. They serve different purposes. And I think that's kind of what you need to think about when you're reviewing an arbitration provision. What is the purpose of the arbitration provision? Why is it in that agreement? Most people think, and it's a fairly popular narrative, that the only reason to have an arbitration provision in a written agreement is to avoid a class action lawsuit. And there is some merit to that. However, I will tell you that both the 2 biggest arbitration forums in the country, the American Arbitration Association, AAA, or JAMS, which is Judicial Arbitration Management Services or Mediation Services, both have created what is called mass arbitration. And it is in essence a class action lawsuit for arbitration where you can get a bunch of different people who have the same or similar claim against the one party. What they're called in arbitration is called a respondent as opposed to a defendant. And it allows them to be administered basically all at once, right? Because they're common parties, common issues. So even though a lot of arbitration provisions are contained in agreements to prevent class action lawsuits, you can have basically mass arbitration, which is the arbitration version of a class action lawsuit. But that's not the only reason why people have arbitration provisions in their agreements. I represent a multitude of clients with arbitration provisions. They all have different reasons, and they're all worded differently. So I think the key when you think about arbitration is this: private contract dispute resolution. I think those are the key terms that define why someone may have an arbitration provision in their agreement. First of all, it's private. Now, what does that mean? That means that I can't get on Pacer or go to the unified court system of New York State and look up arbitration proceedings. I can't look up how many times a party has filed arbitration. I can't look at the docket. I can't look at the awards. I can't look at any of that because it is private. The parties agreed to resolve their disputes out of the public eye. And that is very, very beneficial for certain clients, right? They don't want to be viewed as litigious. They don't want to air their dirty laundry. And the privacy of an arbitration proceeding allows them to do that. They also may have very sensitive subject matter of which they have contracts for the agreements, and they don't want that out in the public eye. Another interesting thing to think about when you think about arbitration and it being private is that what I tell clients and potential clients when it comes to arbitration is bad law does not haunt you. So think of it this way: you file a lawsuit and you get an adverse ruling. It can be binding in that court, in that county, in that district. It can then be used as persuasive authority in other districts within that, other counties, other appellate courts within that state or district. And it has a tendency to sort of mushroom out. Even out of state, it can be used as not binding, maybe not even necessarily persuasive, but contextual authority on how a court that had that issue ruled, right? So you get a bad ruling, you get bad law, it can follow you for a long, long time. Arbitration is different because, again, it's not persuasive or binding authority anywhere. It is based upon that case, and again, because it's private, it doesn't necessarily see the light of day, and that is important to many people. I think also you get a consistency. Again, a lot of the clients that I do work for, and they're all different subject matters, but there can be terms or common issues that arise in an arbitration. And as a creditor, or an extender of credit or a provider of services, a lot of times a good thing to have is that consistency of rulings and how issues are addressed. So that is another good reason why people have arbitration provisions within their agreements. So within that context, you look at, do I have to arbitrate? And again, it depends, right? What does the contract say? There are contract arbitration provisions that make every single claim under the sun possible or contemplated from 1 cent to $1 billion subject to arbitration. And those ones, it typically is because, again, that client, that creditor, that service provider wants to arbitrate. They do, and they are built to do it, and they're set up to do it. There are other arbitration provisions that have what I would call carve-outs. It could be not mandatory, but it could be optional by use of the term may instead of must or shall. It's really important to read through the arbitration provision because they are varied, and I mean, you really need to read through it and know exactly what it is that you're looking with. I've seen arbitration provisions that are 1 paragraph. I've seen arbitration provisions that have been 1 page. So reading through the arbitration provision is very important because, again, the choice of those words, shall, may, must, okay? There are also carve-outs for dollar amounts. You could say, I've seen arbitration provisions that say any claim above $10,000 must be arbitrated. But you can, the ones below that, you can go to court because that's what the parties agreed to. You can have arbitration provisions that have a carve out for everything but collection matters, right? Unpaid invoices, breach of contract. You know, you can again make them as specific as you want or as general as you want, and that's why it's really, really important. So the reality is that in most cases, when I'm presented with a contract and asked to opine on whether or not they have to arbitrate, I read through it, and in more cases than not, in an overwhelming majority of them, the answer is yes, you have to arbitrate because that's what you agreed to, right? You know, there's no exceptions. There is no carve-outs. There may be the use of, you know, may, but it's either party may file the arbitration. I saw that recently. That's a good example. Either party may file the arbitration. Okay, either party may file it, but someone's going to file it because it's subject to arbitration, right? That doesn't make it optional. So you really even need to be very, very careful when you're reading through an arbitration provision and you see may or shall or can, right? Okay, great. But you have to put it in the context of that sentence, that paragraph, and the arbitration provision as a whole. Because in this particular case, there was a prior paragraph that said you're going to arbitrate, all right? So let's go from the assumption that you are going to have to arbitrate. So unfortunately, in my line of work, the arbitration provision comes up after a lawsuit has already been commenced and someone has raised the arbitration provision as a defense, or they have raised it as a bar to the action. They filed a motion to dismiss. So let's talk about that for a few minutes, because that happens. So first of all, under the rules of civil procedure which govern court actions, one of the affirmative defenses that must be stated, otherwise it is waived, is improper forum, improper venue, arbitration provision. So in almost every answer in a lawsuit, you are going to see a laundry list of defenses. And usually one of them is we are not in the proper venue, we are not in the proper forum, this contract is subject to arbitration. So it gets a little bit interesting there, because what ends up happening is that there's a question about whether or not you can waive the arbitration provision. Clearly, the plaintiff, in this scenario that I'm discussing, clearly the plaintiff has waived the arbitration provision by filing the lawsuit. The question is whether or not the defendant has. Well, again, I told you that a lot of times you have those standard defenses that are raised, but courts generally take the position that the longer you proceed in the litigation without really acting on the fact that it shouldn't be in court, it should be in arbitration, then the more likely they are going to find, the court is going to determine that the defendant has waived their right to arbitrate. What do I mean by that? I mean doing discovery, filing motions, filing a counterclaim, attending pretrials, attending status conferences. All of those acts in proceeding in litigation are indicators that the arbitration provision has been waived. Okay, that's something to keep in mind. However, again, in my scenarios, when I'm brought, a file that is in suit and someone has raised the arbitration provision, I have to get involved and get it into arbitration, right? It's because it's early in the stage, almost immediately. So it's interesting, because when you file a lawsuit and there's an arbitration provision in it, a lot of times they will file a motion to dismiss. My argument is that that is not the proper remedy. Okay, and if there are, for all of the practicing attorneys on this webinar, if you have an arbitration provision and you're in litigation and the defendant files a motion to dismiss, you need to tell the court that that's not the proper remedy, because all states incorporate some version of the Federal Arbitration Act. Okay, the Federal Arbitration Act is the national federal guidelines, rules, laws regarding arbitration. All states have incorporated, almost all states have incorporated the Federal Arbitration Act into their own state code. There's variances that we'll talk about a little bit later, or we may get to a little bit later, but they are they're important. And one is that if there is an arbitration provision, then the matter should be stayed pending arbitration. So jumping way ahead to the very end of the presentation now at 11:18 is that you don't want the case to be dismissed. You want it to be stayed, because then you're going to go to arbitration and you're going to get your award, and then you're going to have to go to court to domesticate or confirm that arbitration award. Well, you've already got a case. So you just go back to that court and you say, okay, now we're back. So the proper remedy is to stay it, not to dismiss it. And I raise that because if you proceed in litigation with an arbitration provision, you do it at your own peril, right? Because I'll give you a couple of examples, just anecdotally. One is that they can file a motion to dismiss, and they can ask for sanctions. They can ask the attorney, they can ask the court to have the attorney sanctioned or the creditor sanctioned for clearly filing in the wrong form. And I will tell you that sometimes they are awarded that. Okay, so you are, by proceeding in the wrong forum, you are opening yourself up to exposure in the form of sanctions. Another example is in the state of Florida. In the state of Florida, if an attorney gets involved for the defendant, makes an appearance, and they file that motion to dismiss, and maybe the plaintiff in that case voluntarily dismisses it before the court can rule on it, that attorney is more than likely going to then file a motion for attorney's fees. And again, the courts take that very seriously, and sometimes they grant it. So there's another example of opening yourself up to potential sanctions in the form of monetary damages for attorney's fees. I believe in the state of New York, if you file an action and an attorney gets involved for the other side and files an answer, you are not allowed to necessarily voluntarily dismiss it. You have to get permission of the other side. And that being the case, they are only going to want to dismiss the case with prejudice, which means your case is done. If it was without prejudice, it means that you could go to arbitration or whatever else. If it's with prejudice, you got a problem, right? So it is not as simple as just saying, well, we'll just ignore the arbitration provision and we'll proceed to court. You can do it because there are pros and cons to arbitration, which we're going to discuss next. But you have to be aware that there is exposure by doing that. Okay, so I hope I answered that first question about do I really have to arbitrate? And again, it depends. Read the contract, read it thoroughly, read the arbitration provision. There may be a carve out, there may not. So the second topic that I wanted to talk, the second question I wanted to answer is, how is arbitration different than litigation? So I kind of touched a little bit on it in previously, but I think in general, whereas I described, arbitration as private contract dispute resolution, right? The key terms. The key term for the answer to this question is informal, okay? And so what that means is that the rules of evidence do not apply. The rules of civil procedure do not apply. They can apply. It depends on the sophistication of the parties. It depends on the arbitrator that you get. But in general, it is informal, casual. It is, I want everyone to come in, I want to hear the story, and then I'm going to make a decision. That's the general proposition about how arbitrators approach this. It's important because in my world, commercial collections, where it's business to business, sometimes there's a guarantor, but business to business, incorporated entities deemed sophisticated in the eyes of the law. If you're in court, a non-attorney cannot represent a company. So you have a case where you have, John's Plumbing, right? And John Smith is the owner of John's Plumbing, and they're an incorporated entity, but it's John, and he's got his brother helps him out, and his wife does the books. Okay. John, if he weren't an attorney, would not be able to appear in court on behalf of the business entity, because corporate law in the United States says that an incorporated entity is a separate person. So if you have the entity and it is this person, and then you have John Smith, who is this individual, John Smith would be representing an entity. John Smith is not an attorney. That would be the unauthorized practice of law. Arbitration doesn't matter. Okay, you can get an attorney. You are advised to get an attorney. It's probably the smart thing to do, but you don't have to. And I've been doing arbitration since the day after I was sworn in November of 2001. The day after I was sworn in November of 2001, I did an arbitration. Okay, that's how long I've been doing it. By the way, I lost, but I learned a lot. and I've been doing, I'm going to say I've done over 1,000 arbitrations in my 23 years of practice, and I can count on maybe both hands, maybe just one hand, the number of cases that I lost. And I credit it to losing that first case, because I learned a lot, which is sort of being addressed in this question, is how is it different than litigation? No civil rules, no evidence, informal, not on the record, more than likely. You don't have a stenographer, but it allowed me to find my voice. There may be some clients and some businesses that are on this webinar, that you're on this webinar because you may have to testify at an arbitration, or you may have to testify. You may be your company's representative, okay? If that's the case, arbitration is great for that, because again, you don't go behind and sit next to the judge and on the witness stand with a microphone in front of you. You know, even when we were doing them live, the person was sitting right next to me, right? And now with virtually, or however else it's done, it's like everybody in a room. And for the person who is uninitiated to the legal process, or the quasi-legal process, being able to find your voice as a witness, as a representative for your company, arbitration is really great for that, because it's really low stress, right? So that is, again, one of the ways that arbitration is different than litigation. So it's important to know that with arbitration, that because this is one of the questions that was asked prior to the webinar with the sign up, and I appreciate it. It was, I understand that arbitration is more expensive. Is that the case, right? And the answer to that question is yes, it is, right? But it's a cost benefit analysis, right? So let's talk about that. It is initially more expensive, because if you go to, let's throw out the $15,000 claim, okay? We'll just use that as our sort of base. You have a $15,000 claim. You go to court. You're more than likely in the county court. Actually, if it was $14,000, you would be in the county court. That's going to cost a couple $100 in filing costs, okay? Probably around $250, $300, depending upon your state, your county. But the court of lowest jurisdiction is in that, you know, $250 to $300. They may nickel and dime you as you go through the process. It's $5 to file this motion. It's $15 for this, et cetera, et cetera. But it's probably going to run about, I don't know, $500 to get the case filed and get it through to judgment, just as a general proposition, right? Okay. So arbitration is it is about what, I think I have it written down here. I did. I think it's like $975 is the filing fee. So $975 is the filing fee, but that covers any case up to $75,000. And $75,000 is an important number, because one, that covers a lot. I mean, think about my 23 years of doing arbitrations, I'm going to say that 75 to 80% of them were less than $75,000. So there's the filing fee. And yeah, that may give you a sticker shock. But the nice thing about it is, if you go to the American Arbitration Association, AAA, that $75,000, unless there's a counterclaim, unless there's a request, or unless the arbitrator deems it necessary, It's going to be, well, no, actually, it's going to be handled under the expedited procedures. So what does the expedited procedures mean? It means that it could very well be done on documents. If there's a hearing on the matter, it is going to be by telephone or by video. And also, it means that the arbitrator's compensation is capped at $950. And that $950 is supposed to be divided up between the two parties. So that $950 is more like $475, right? If I do my math right, yeah, $475. That's why I became a lawyer, because I'm horrible at math. So I needed to almost get out my calculator to double check on that. So it's supposed to be paid equally by the parties. That gives you 1 day of hearing, all right, if there's going to be a hearing. But more than likely, it's going to be done on documents, and we'll get to that in a second. So it is somewhat more expensive, which is different than litigation. But there are benefits to that, and one is that there are no free counterclaims in arbitration. Okay, a counterclaim is treated as another claim, a claim of which the filing fee has to be paid. Right? In litigation, a lot of times a party will file a counterclaim to gain leverage at the negotiation table. That's not the only reason, but it is a reason. So that's a lot more difficult in arbitration, because if they want to file that counterclaim, then they're going to have to pay the same $975 filing fee that we paid, you paid, the client, the creditor paid to file the arbitration. So no free counterclaims. You also, again, you have to pay your fair share of the arbitrator's compensation. So in the scenario of $950, it's $475, and you get your hearing and you're out the door. If you start requesting discovery, if you start requesting motion practice, then it more than likely is going to be taken out of the expedited process, and then the arbitrator starts charging by the hour, and it gets more expensive. All right. So there's a lot of good reasons to keep it in the expedited procedure, keep it under that if it's that $75,000 or less claim, and then you can, again, get through quickly, because the arbitrator is supposed to have the hearing within 30 days of the appointment. Now, again, as we'll call me a seasoned arbitration practitioner, the reality is that I don't think that I've ever had one within 30 days. And it is not because honestly, it was usually me, right? So there's a couple things to consider on that point. Is one is that the question is, how is the hearing going to be done? Is it going to be done on documents only by agreement of the parties? Is it going to be done on documents only because the respondent is not participating? It's funny, because a lot of people like to go to court, because I think the national data says that like 80% of all litigation ends up in default. Guess what? It's not that much different in arbitration, except the fact that you don't get a default, right? What I mean is that the other party doesn't participate. So when that happens, what I routinely do is say, I want this matter to proceed on the documents. Some arbitrators will say that's fine. Some arbitrators will say, we'll do that, but we're going to give the respondent notice that we're going to proceed on documents unless they object within so many days. And therefore, when we've papered the file, we've documented it, we've dotted our I's and crossed our T's, and we're going to proceed on documents only. So that is another distinction between arbitration and litigation, is that there is no default. So typically, if you go to court, if the other side is served, They are given a time to respond. They do not respond in that time. And then the plaintiff files a motion for default. And a lot of times it is signed by a duty judge, or there's a non-oral hearing, or the court establishes some sort of deadline for it to be responded to. And if it doesn't, then they review the motion and the entry. And again, 9 times out of 10, they grant a default. That's not the way it is in arbitration. You still have to put on your proof. It's weird. So I stumble on this a little bit in the sense that not filing answer is deemed a denial of the claim, or not filing a response is deemed a denial of the claim. It is not a denial of the claim as to the merits. That means that the respondent is denying liability for the claim, right? It's a little bit weird. So you don't have to file an answer. You don't have to file a response, but it is still deemed that you are denying that the respondent is denying the allegations and denying that they're liable for the debt, or they're denying that the damages are what they are. So you have to put on your proof, right? And so there's no default judgments, but it's not a lot different than litigation in the sense that you don't do a motion for default, you do what's called a dispositive motion or a brief, and you do the same thing. You set forth your claim, you have an affidavit by a person with knowledge or a keeper of the business records. You put on your exhibits incorporated into your affidavit, typically the agreement, any notifications of breach, your calculation of damages, invoices, the whatnot, right? That establishes what your damages are. And it's presented to the arbitrator in written form, and it is ruled on. So it's not a true default, but it is a rather quickly a presentation of the evidence and a ruling by the arbitrator. And so that's, again, slightly different. So I sort of hinted at it, no civil rules, no evidence, right? In the typical expedited procedure case in arbitration, again, there is no discovery. There's no depositions. There's no motion practice, like motions to dismiss or motions for a more definite statement or anything like that. Again, most arbitrators take the approach that I'm letting everybody throw it up on the wall, okay? And I'll decide, right? And so that's why you should be getting to a merit hearing much sooner than you would get in a traditional state or federal court, right? So think about that, right? There's the trade-off. Again, my practical experience says that it typically is not going to happen in the 30 days as set forth in the expedited procedures, but it is also not going to be a year later after the filings of motions and merit hearings and all of that sort of stuff that typically takes place in a litigation setting. So if you are allowed to do discovery, which again, I've had, right? It is no admissions, right? So in discovery, you have 3 forms. You have interrogatories, what's your name? It is admissions, admit that this is your name. And you have requests for production of documents. Give me a document that shows what your name is, right? I mean, so no admissions, right? So you can't sit there, and again, the thought is that you cannot then go and use that as a way to short circuit the merit hearing by saying, look, they admitted that their name is so-and-so, right? And therefore we win. All right, so there's none of that. There's also, no depositions, right? Again, they want to streamline it. They want to make it economical. They want to make it efficient, and they want to make it timely. So that overall is sort of the biggest difference between litigation and arbitration. Okay, the last stated topic is what happens after I arbitrate. So again, and we'll send you a flow chart of like how arbitration works, from the commencement of it to the end. So we're going to jump to the end. You have an arbitration provision, you arbitrate it, you get an award in your favor. Okay, what do I do? So this is sort of a crossover between the last question and this question. How is it different? How is arbitration different than litigation? Okay, litigation, you get a judgment, all right? A judgment entry or an order, right? And that is already in court. It's from that court, and it is enforceable, okay? The award, again, private contract dispute resolution. The court doesn't even know you exist up until this point, right? So it is not self-executing. It does not have the force of law behind it in and of itself, but it does have, through the Federal Arbitration Act, codified in the various states in some way, shape, or form, it does have a structure where, as long as you follow it, you will have the force of law behind you. So you have this award, and what you typically have to do is you have to file what's called an application for confirmation of the arbitration award. And that is where you take the award and you file it in court, and you ask the court to make it a judgment in that court. And in essence, in its most basic form, you have to include the award, and you have to include the contract that had the arbitration provision in and of itself. All right. So again, difference between arbitration and litigation is, now you got an extra step, right? Before you go to court, then you just start to execute on your judgment. Here, you get an award, then you have to go to court, and then you can execute. So a lot of times, as many practitioners, again, if there are practitioners on this webinar, or maybe again, you've experienced this as the contact for your business, right? And that is that you file a lawsuit, you get a judgment, and then all of a sudden they challenge the judgment. They come out and they say, oh, I never got service or whatever else, right? There are remedies for that. Typically it's called a 60B rule, a Rule 60B motion, a motion for relief from judgment. So one of the other nice things about arbitration, because you've gone through that extra step of going to arbitration when your contract has an arbitration provision, is that you're protected in a very large degree. And by that I mean is that there are very limited grounds to challenge an arbitration award. It is, in essence, the main ones are fraud on the part of the arbitrator, coercion on the part of the arbitrator, failure to allow a postponement when one is requested, right? And so you heard me say on the arbitrator. They can't sit there and say, well, creditor did this, creditor defrauded me. That's not a defense under the Arbitration Act. It's fraud on the part of the arbitrator, okay? Courts do not want to get involved in this. They were not there. They did not see the arguments, because again, what I said to you is you have to do the application, you have to have the agreement calling for arbitration, and you have to have the award. You don't necessarily have to have all of the underlying evidence you presented. So in essence, the court doesn't know what the arbitrator had or didn't have or heard or didn't hear. And just like appellate courts don't want to second guess trial courts because they weren't there, and there's no, and again, in an arbitration case, 99 times out of 100, there's not a transcript of the hearing. The presumption is that the arbitration proceedings were in conformity with the act, that they were fair, that that due process was given. So they're not going to step into that. So there are very, very limited grounds, and there's a very, very limited time period. The Federal Arbitration Act says you have 90 days from the award. Okay, Ohio, where I am, is 90 days as well. Some states give a little bit more. Some states give a little bit less. Yeah, it's important as a practitioner, or again, a creditor or a service provider, to look at what your state says about the time period. But the general framework is 90 days. If it is challenged more than 90 days after the award, the court doesn't have jurisdiction. And I will tell you that, you know, it happens that people challenge the awards. And again, like I said, I lost my first arbitration, and I haven't lost a lot since then. I'm not sure that I've ever lost an appeal, because the law is really, really clear on that particular point, and that particular timeline. So if it's more than 90 days, the court doesn't have jurisdiction, and the court should not hear that argument, right? So I say that to you because, as a practical point, when I do arbitrations, this goes to the timeliness issue, right? When I do arbitrations, and if the other party does not participate, I don't want to do this for myself, and I don't want to have my clients have to go through it. If at all possible, I wait more than 90 days before I move it to court, because I don't want to have done what I did and have them do what they did, file an arbitration, do an affidavit, attend a hearing, et cetera, et cetera, et cetera, and then have it all be undone by not waiting the 90 days because I got antsy and I really wanted to get that judgment. If you can wait the 90 days because the other party has not participated, then do it. You take out 99%. Now, actually, you take out 100% of the defenses to that arbitration award. So from a practical standpoint, you know, that's what you do. So you got your award, you've moved for confirmation of the award. There are no challenges to it. They have not filed a motion to vacate, a motion to correct, a motion to modify the award based upon clerical error, fraud on the part of the arbitrator, coercion on the part of the arbitrator, not granting a continuance when one was requested. Then you get your judgment. And it's just like you were in court in the first place. And then you can start to do your executions, right? So again, extra steps, undoubtedly, slightly more expensive, undoubtedly, but for the most part, and again, in my 20 plus years of doing this, you know, you're talking about claims that would be in the higher jurisdiction of the court. You know, again, a contested matter, you're not getting a trial day for a year, right? And 99% of the arbitrations that I've handled, they're not done in 30 days, but they're done in 90 days, which is not bad, at all. Now, I tell you that because I do want to tell you a little bit of a war story, right? I will sort of bookend this, and we'll see if we have any questions. So again, I've again acknowledged my first arbitration was a disaster. I lost. And I mean, I did. I asked questions that I shouldn't have asked, didn't ask questions that I should have asked, but I learned from it. And I'm sitting there telling you, because again, I'm a big advocate for arbitration. It is a tool in your toolbox, and if you have to arbitrate, then you should do it well. You should learn how to do it well. You have opportunities to learn how to do it well. And in general, it is a pretty efficient process. Now, I say that, but I want to sort of give you the outlier. And the outlier was a case that I think we filed the arbitration in 2011. And the matter, I finally closed the file in either the end of 2023 or the beginning of 2024. And this is sort of a cautionary tale because, again, if somebody wants to arbitrate, if they have the arbitration provision in their contract because they want to arbitrate, then, and they're willing to go to the mat for it, then you're going to arbitrate. And I tell you that because in this particular case, we filed in 2011. We finally had we had 8 days of video hearings spread out over a 3-month period in early 2023, I believe. And that was because this matter went to the appellate court in New Jersey 3 separate times. It also went to a federal court in Pennsylvania. And yeah, it went to a federal court in Pennsylvania. And that is a horror story, that an arbitration would take, in essence, 12 years with 8 days of hearing after being in state appellate courts 3 times. You know why? Because they didn't want to arbitrate. Not my client, the other side. The other side, which ironically had an arbitration provision in their agreements that they used with their customers. And they went to court many, many times to defend that arbitration provision within their contract. But in ours, they did not want to go to arbitration, and they fought it tooth and nail. And my client, our client, fought it tooth and nail as well, to the extent that it went to the appellate court 3 different times before we got it back to arbitration, where it should have been all along. And then we had a lot of discovery. It was a big dollar amount. I mean, I'm not gonna lie about that, or I'm not gonna be honest about that. It was a high dollar amount, right? But it was, I think I had 10,000 pages of discovery. So it was kind of a crazy case. You know, it in a lot of ways, I will say that it was sort of my crowning achievement. I think it was the greatest case that I've ever been involved in. It had so many twists and turns. I would like to write a book about it, but I'm not. But again, that is the extreme outlier. But you know, you should be aware of it. So, Madison, do we have any questions in the chat box? Doesn't seem like it. Okay. Does anybody have any questions that they want to type into the chat box? Okay. Well, it's 11:54, which I think means I'm either going to get done early or I've gone over. I don't know which, but anyways. So I've got to pull this up and read my closing script. So thank you all for attending today's Weltman webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you'd like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on various topics such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library and a follow-up email. Thank you again for attending, and I hope you all have a great rest of your day and rest of your week. Thank you very much.